Many people will say that Congress has oversight powers over the Department of Justice, so they can look into the DOJ's operations. Well, Congress has oversight over DOJ's operations to the extent that it has the power of the purse. It can subpoena operations, it can subpoena how the DOJ is spending its money, it can investigate the various officers of the DOJ, it can investigate their internal operations. But what the Congress does not have any oversight authority over is how DOJ conducts its ongoing criminal investigations. This distinction is very important because under the Constitution, Article 1 vests upon Congress the power of the purse and gives Congress, by way of the power of the purse, oversight authority over the various branches' operations. They can look into how the executive branch is doing its business. But when it comes to conducting criminal investigations and indicting and prosecuting criminal investigations per the laws that are already on the books, that enforcement authority, that executive authority, absent showing of callous disregard of or other elements that are outlined in the Ricci test for the Ninth Circuit, and I assume that the other circuits would adopt this Ninth Circuit's Ricci test, but if they don't, they probably have similar tests that test whether any sort of intrusion is warranted. And we saw this play out with the Article 3 branch of government, the court, with the Eileen Cannon special master case. And the courts have equitable jurisdiction. They can legitimately intervene into certain DOJ actions if they find that the DOJ has displayed callous disregard for the defendant's rights. That power of judicial review and equitable jurisdiction doesn't exist for Congress. Congress's powers are limited to oversight when it comes to matters that are attached to the powers that are enumerated in Article 1 and vested to Congress. Intervening into DOJ criminal investigations isn't part of that oversight. In fact, intervening and interjecting into DOJ criminal investigations is judicial in the case of Eileen Cannon and legislative overreach if the GOP House impanels a committee solely to intervene and interject and corrupt ongoing DOJ investigations. And that is because, according to the Constitution, per the Constitution, Article 2 branch of government, which is the executive branch of which the DOJ is a part, has the exclusive authority to execute the laws of the land. So Congress doesn't have the right or the authority or the apparatus to investigate crimes. That job lies with the DOJ. And we see this playing out with the January 6th committee. They don't have the authority to investigate crimes. They have the authority to investigate the executive branch for what was happening in the executive branch. They have the power to ask and subpoena executive branch officials about what was happening with the executive branch's operations, how they were handling themselves, what was going on in the executive branch while the transition was going on. But if the committee, for example, went in to ask how the executive branch and the president was conducting its business on a day-to-day basis, you will notice that even when it is a matter that is close to the insurrection and the treason plot that is part of the insurrection, Donald's lawyers and even the DOJ, by refraining from indicting Mark Meadows and Dan Scavino for contempt of Congress did not step over the line of executive privilege, did not step over the line of the executive branch's authority to conduct its business the way that it saw fit. And that's where executive privilege comes into play. And that's where it shields the executive branch from DOJ, its own DOJ's investigation, from Congress's investigations. And until there's showing that there is a crime afoot, until there's probable cause of a crime, it would be an uphill battle for any branch of government to get into the executive branch's executive powers. So it is a very nuanced sort of differences between the two branches and the three branches of government. But you have to understand that just like DOJ cannot go into Congress and say, okay, we're going to draft the laws which we are then going to enforce, and then tell the courts, the Article 3 branch, that no, we're not going to even take the cases to you. We are going to draft the laws. We are going to go ahead and prosecute in our courts, not an Article 3 court, in an Article 2 court that we're just going to come up with. That's the kind of overreach that would be an enforcement branch, an executive branch overreach into judicial review, which is the Article 3 branch's power, and drafting of the laws, which is Article 1 branch's power. So while the branches can look into the operations of each of the other branches and have review authority over them to the extent that the Constitution allows, what the different branches cannot do is intervene and impede into a territory that is enunciated in the Constitution as being solely the purview of a particular branch. In this case, the investigative, prosecutorial, and enforcement authority of the Constitution is vested in the executive branch. So absent showing of callous disregard, neither the judiciary nor Congress can intervene in an ongoing DOJ criminal investigation and compromise the integrity of that prosecutorial process. This case, if the House GOP decides to take it and ask and subpoena, the DOJ will move in the DC Circuit courts to ask for an injunction, ask to block this subpoena from Congress. If any district court rules in favor of Congress, which I doubt there will be in the DC Circuit, then the case will go to the DC appellate court, and they will rule in favor of the executive branch. The case is not exactly the same as the Special Masters Review case with Eileen Cannon, but the larger topic of the separation of powers issue remains the same. And the topic of overreach by another branch into core executive functions remains the same. So I want to leave it at that. There are many people who are going to tell you to STFU like they have STFU'd me about Congress having oversight authority, even when they didn't know how to spell oversight properly. But that's where we are. I want you to be aware that it's not going to go anywhere. And in fact, it's not even going to delay the DOJ's investigations, because the DOJ will continue its investigations. And no Article 3 court is going to listen to Congress wanting to intervene into an ongoing criminal investigation and then say, oh yeah, we're going to stop that investigation and review whether it needs to be intervened by Congress. In my mind, to my recollection, there has never been a case where Congress has sought to intervene in a DOJ criminal investigation. Just like the 11th Circuit pointed out, that there's never been an instance where, absent showing of callous disregard, a district court had exercised its equitable jurisdiction to intervene in an ongoing DOJ criminal investigation. That has never happened. And people need to understand the severity and the seriousness of this. Donald Trump is using sitting officials, sitting members of the various branches of our government to get the branches of governments to attack one another. And that, if that is not subversion, I don't know what is. And it needs to, the alarm needs to go off, and every legal expert and legal mind needs to come out and face this and confront it and let people know that there is nothing that Congress can do to stop an ongoing DOJ criminal investigation. Its oversight authority does not overreach into ongoing DOJ criminal investigations that explicitly and enunciatedly falls within the Article 2 power of enforcing and executing the laws of the land.